In this episode, we examine 3 separate probable cause hearings conducted in the courtroom of Judge David Fletcher of the Harris County Criminal Court in Houston, Texas. A probable cause hearing takes place shortly after an individual has been arrested, particularly when the arrest occurs without a warrant. Under Article 15.17 of the Texas Code of Criminal Procedure, an arrested person must be brought before a judge without unnecessary delay. During this initial appearance, the judge advises the defendant of their rights and evaluates the information presented by law enforcement to determine whether probable cause exists to believe the person committed the alleged offense. If the judge determines that probable cause is lacking, the defendant must be released. Our first hearing occurred on November 4th, 2024, after the defendant, Raquel Rodriguez, was charged with driving while intoxicated on October 28th, 2024.
Okay, Max, who do you have here?
Raquel Rodriguez.
Vic, you ready? Okay, this is page 20.
On page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1 leg stand. He also noticed that I think she took off her boots for the 1 leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know.
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 a.m. and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push 1 button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
All right, please take a seat.
Judge Fletcher found that probable cause did not exist because he concluded there were not enough objective signs of intoxication to justify administering so-called SFSTs, or standard field sobriety tests. Since field sobriety testing prolongs a traffic stop and results in an extended investigative detention, officers must have reasonable suspicion that the driver has committed an intoxication offense before requiring such tests. In this case, the only evidence was the smell of alcohol and Ms. Rodriguez's statement that she had consumed 2 drinks, the last one approximately 2 hours before driving. Based on these facts, Judge Fletcher determined there was no reasonable suspicion to extend the stop to conduct field sobriety testing under both state and federal law, including Article 38.23 of the Texas Code of Criminal Procedure. Evidence obtained through a constitutional violation, such as unlawfully extending a traffic stop, cannot be used against the accused in a criminal prosecution. Because the results of the field sobriety tests were inadmissible, Judge Fletcher ruled that no probable cause supported the arrest, and the state ultimately dismissed the charge on February 24th, 2025. The next probable cause hearing we review also took place on November 4th, 2024. The defendant, Kean Shaw, had been charged on October 28th, 2024, with fleeing a police officer in violation of Section 545.42 on the Texas Transportation Code, which makes it a misdemeanor for a driver to willfully fail or refuse to stop when signaled by a pursuing police vehicle.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27th, 2024, the officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When the officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause.
Dismissing the case.
I know probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life. All right?
Yes, sir.
All right, man. Good luck.
Judge Fletcher again found no probable cause, noting that there was no specific allegation explaining how fast the driver was traveling or otherwise justifying the initial stop. Although the Transportation Code does not expressly require that a stop be lawful in order to support a fleeing charge, constitutional protections still apply. If a stop violates the Fourth Amendment or Texas law, then, as discussed earlier, Article 38.23 of the Texas Code of Criminal Procedure requires suppression of any evidence obtained as a result, including an officer's testimony that the driver failed to stop. Under the Fourth Amendment, an officer may not detain a vehicle without reasonable suspicion supported by specific and articulable facts that a traffic offense or other crime occurred. In the 2005 case Ford versus State, the Texas Court of Criminal Appeals rejected a stop where the officer merely claimed the driver was following too closely without describing the actual distance between the vehicles, holding that a conclusory allegation was insufficient to establish reasonable suspicion. Consistent with that reasoning, Judge Fletcher concluded that the record lacked the specific, articulable facts necessary to justify the stop and therefore lacked probable cause for the arrest. The state dismissed the charge the same day. The final probable cause hearing in today's episode took place on January 27, 2025. The defendant, Francisco Cerda, had been charged on January 22, 2025, with engaging in organized criminal activity under Section 71.02 of the Texas Penal Code. This statute criminalizes committing or conspiring to commit certain offenses with the intent to establish, maintain, or participate in what the law calls a combination, defined in Section 71.01 as 3 or more individuals collaborating in ongoing criminal conduct. The statute covers numerous offenses, including drug trafficking, robbery, burglary, assault, murder, money laundering, and, in Mr. Cerda's case, theft.
The last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wanted to touch on wrong offenses.
Is that C or an S?
The C judge, the RDA.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes, Judge.
I don't even know where to start.
Judge, my concern is, if you may, I want to create some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this fuel. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the four corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person, right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude, I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We have to await the OR, and we don't have that at this time.
but I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because 7102. A person commits an offense if, with intent to establish, maintain, or participate in any combination or in the profits of a combination, or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. One is murder, capital murder, arson, yada, yada, yada. Two, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number four, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness.
He's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not gonna hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time on it to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay. All right, for sure.
Judge Fletcher determined that probable cause was absent because there were no specific allegations regarding Mr. Serta's conduct beyond his mere presence inside the stolen U-Haul. As explained by the Texas Court of Appeals in Amarillo in the 2000 case Munoz versus State, a conviction for engaging in organized criminal activity requires proof that the defendant intended to participate in or maintain a group that agreed to work together in a continuing course of criminal behavior involving more than one offense or episode. The court further clarified that simply being present during a single criminal incident is not enough to show an agreement to engage in ongoing illegal activity. In Mr. Serta's situation, the only claim was that he was inside the stolen vehicle, with no evidence suggesting involvement in multiple crimes or an agreement among the defendants to operate together as a continuing criminal enterprise. As a result, Judge Fletcher found no probable cause, and the state dismissed the charge against Mr. Serta on February 24th, 2025. These hearings demonstrate why probable cause determinations are such an important safeguard in the justice system. When someone is arrested without a warrant, their liberty is immediately restricted, often based solely on an officer's account. A probable cause hearing provides a first meaningful opportunity to ensure that the arrest is supported by reliable and admissible evidence. Judges like Judge Fletcher, who carefully scrutinize the facts instead of automatically approving arrests, help protect constitutional rights, and reinforce the principle that government authority must remain subject to oversight. By dismissing arrests that lack probable cause, courts not only safeguard the accused, but also strengthen public trust in the fairness and integrity of the legal system. Let us know in the comments if there is another case or courtroom proceeding you would like us to review. Thank you for watching, and don't forget to subscribe and share so we can help build a more informed society.